For the first time, the U.S. government has provided an answer on how patent protections apply to art, inventions, products made with the help of artificial intelligence. The patent professor joining me on the program, Dr. John Rizvi. What did the government say, Dr. Rizvi?
Yeah, well, I wish that they had provided better guidance. So President Biden issued an executive order asking the Patent Office for guidance for inventors on how much of their contribution is enough if they use AI to help them in developing the idea. And the only the guidance provided by the Patent Office is that the contribution needs to be a significant contribution.
Oh, wow.
and now
what does that mean?
We need somebody,
now
we need someone to define what significant means as far as contribution for an inventor to be listed as an inventor.
Obviously, this issue will be addressed again by the Patent Office and other regulatory bodies. Well, that's the way things aren't now, whether it's somebody writing something or video production or a piece of art, maybe even music, all that stuff. AI will be a part of it. And I suppose you could even make an argument that, I own the software, I subscribe to the AI service, or I purchase the AI software for something like this. So ownership goes, the ownership is that of the artist or the engineer or whoever's producing that. That could be an argument as well. This is all mine. These are all my tools. This is what I produced. So do you see a legitimate argument there?
And you hit the nail on the head by these are all my tools, because this isn't a new argument. In fact, as far back as the 1800s, there was a question whether a photographer was the author because he used a camera, and the camera was is it any different than a robot to take a photograph? He didn't paint the picture. He used this camera to take a photograph. In that case, there is no question that the camera was just a tool, and the photographer is the one that chose the location, the background, the lighting, and had enough input. No different than, a paintbrush is a tool for a painter, or a chisel is a tool for a sculptor. The problem with today's technology is that it's an incredibly powerful tool. It's not like a paintbrush or a chisel or even a camera. The part that the machine or robot does as compared to the human input is substantial. So the human being might just have a prompt that they enter, and the rest of the art is created by the software. And that's the issue, and the question that President Biden asked the Patent Office to illuminate on is, well, how much contribution does the human have to have in order for them to be listed as the inventor or the author? And the reason this is important is that the Constitution only provides intellectual property protection for the works of an author or inventor, and that's been interpreted to mean a human author or inventor. There's no intellectual property if something is entirely created by machine.
Yeah, well, it's the human who made the choice of topic A, B, and C to provide the input in order to generate whatever. I mean, don't you see an argument there as well? I mean, it's just another tool.
Yep, that's the argument, that it's just another tool. Now, the opponents are, their position is no, it's not just another tool. That somehow AI is fundamentally different than any tools that have been available to inventors and authors in the past.
Wow.
So the thing is, the more sophisticated the tools become, now we have detectors to determine if AI has been used to create a story or book. So there's software now that can detect the use of AI. And teachers and professors are using that to catch plagiarism, and also to make sure that a student's work is really their own work, because they want to know they don't want to know how good somebody is at creating a prompt. They want to know, do you know the subject matter?
Yes.
And can you put coherent thoughts together yourself?
From Nova Southeastern Law School, Florida, the patent professor, John Rizvi, is my guest, and AI and how much it contributes to whatever's produced, either in written form or music form or picture form, is the issue. And the government at the moment squeamishly says only, what was the word, significant or
the contribution, right? How much of a contribution is enough? And the answer is, well, it has to be a significant contribution.
Which means, okay. At this moment, Doc, we're at a point where if something is churned out by some robot, some AI software, the human still needs to go through and proofread it and make corrections to it. I mean, that's part of the process as well. Listen, do you think that we really need an AI threshold? Do we need those standards? And then who produces that? We got literary societies, we got musical business and societies. We got different industry groups that could be providing thresholds for that. We don't need the government to provide that threshold for us.
So you bring up a good point about the post-editing. So clearly, I think the easiest way for an inventor or an author to show a significant contribution is after they get the results back from the machine. So the more editing you do, the more revisions that are done afterwards, that's the best advice I have for strengthening your case as making a significant contribution. You get involved in the editing.
I think, yeah. I'm sorry, Doc. I'm kind of running out of time. But look, I look at this AI stuff. To me, it's like, how's that different from ghostwriters? How's that different from audio correct, where somebody can't sing worth a flip like J-Lo, but somehow is the computer puts everything back in tune? Or even you got writers who produce music and songs and will never be recognized for what they produce. And it's the superstars that sing eventually make all this stuff famous as well. The only difference is that it's faster. The computers will churn it out in a few seconds versus the ghostwriter and the music writers. That will take them time to produce.
Right, and is this, if they do focus on the use of AI, is it hurting those the more honest you are? Because what happens to the author or inventor that doesn't disclose the use of AI versus somebody that clearly discloses it? There's already been a case of an inventor, Stephen Thaler, that listed AI as the inventor, and his application for a patent was rejected because he openly listed the inventor as AI versus listing himself. And the question is, had he listed himself, how would they even know? Is there really any way to detect if AI has been used to come up with an invention? Now, there are AI detectors for written material like books and stories and such, but not for inventors.
Well, I hope that dude didn't invent like the cure for cancer. We need that to come to market as soon as possible. Thank you.
Regardless of how it was created, right?
Absolutely. Yeah, we need
Good
that.
Point.
Thank you, Professor. From Nova Southeastern Law School in Florida, the patent professor, Dr. John Rizvi.